and this is being submitted privately. And the question reads, does the employee have to provide a reason when they're making a statutory flexible working application?
So the very short answer to this is no, they don't have to give you a reason, but the employer can ask, and obviously it is sensible to ask the reason for the flexible working request being made, particularly if any of those factors would fall into protected characteristics. So for example, if the request is in line with childcare responsibilities or health conditions, because obviously you want to be ahead of the game and there's a potential risks there around refusing the request that you're making. However, the other aspect to consider is, failing to provide a reason also wouldn't be grounds for automatic refusal. So if the individual isn't forthcoming with that information, that doesn't mean that you simply refuse the request. And we highlighted earlier that there's a specific requirement on employees when they submit a request. So things around obviously putting it clearly in writing, how it's going to affect their employer. But again, if individuals don't manage to comply with that request, we wouldn't recommend that you simply refuse it on that basis. Having the meeting with them gives you an opportunity to cover off some of that additional information that they may have missed out in the written request that they've made.
Yeah, if I could just interject there, I think that's one of the things that holding an employee to such a specific requirement before you're considering a request. I mean, again, you raise the risk of these reasonable adjustments and indirect discrimination elements rearing their ugly head again. That by just sort of taking that as they've not ticked the boxes, so we don't have to now comply and we can just go back and say no. Then for example, you run the risk of a continued failure to make adjustments, or continuation of a practice criterion of provision that puts them at a disadvantage. And take, for example, if they fail to comply, perhaps they have a disability that gives them different difficulties with forms and written correspondence, dyslexia or something similar, then I think before you just bounce these things back, we need to be looking very carefully at why they might not be compliant. And although we might think, rub our hands together with glee, we don't have to do this, they've not ticked the boxes, we've got to kind of look back and see why that is before we process it any further, for sure.